welcome to you all. I'm Carolyn Richardson, and I'm a Senior Legal Counsel in the Credit Legal Team at the Commerce Commission. Welcome to my session on Sections 9CA and 41A of the CCCFA. I'm going to run through what the sections require you to do and why it's important that your processes comply with the new requirements. The changes under both sections are not just for the benefit of a borrower, guarantor, dispute resolution service, or the Commission. They also support your compliance with the relevant requirements of Sections 9C and 41 of the CCCFA and ensure you have records of how you've complied if they're needed for some later reason. Sections 9CA and 41A were introduced as part of the wider CCCFA reform in 2019 and came into effect on the 1st of December 2021. The aim of these sections is to address non-compliance with affordability and suitability assessments, noting that unaffordable or unsuitable loans are one of the largest sources of harm to borrowers. These section changes are part of 3 measures that were introduced to clarify affordability and suitability requirements, streamline enforcement, and create stronger incentives for compliance. Those 3 measures are a regulation-making power to prescribe minimum requirements for affordability and suitability tests, an increased onus on lenders to verify details provided by those applying for loans, and lenders are required to keep records that demonstrate their loans are affordable and suitable and that their fees are reasonable and cost-based. The sections also improve the implementation and enforceability of rules around responsible lending by allowing for clear minimum standards to be set and strengthening the penalties for breaches. Previously, there was no legal requirement for lenders to keep these records, which made it difficult to obtain evidence if we were investigating a complaint. The sections enable the Commission to obtain records more quickly and focus investigations on whether the recorded inquiries made were reasonable and were enough to satisfy the lender that a loan was suitable and affordable, or that fees are reasonable. Section 41A, which builds on Section 41, recognises that it's not enough to simply set and forget fees. Instead, it is now clear that there need to be reviews of fee assessments when material costs relevant to a fee change. Section 9CA requires you to make and keep records that show you have made the required inquiries about the loan's affordability and suitability for the borrower under Section 9C, including the results of those inquiries. The records must demonstrate how you satisfied yourself that the loan meets the borrower's requirements and objectives and can be repaid without the borrower suffering substantial hardship, or that a guarantor can comply with the guarantee without suffering substantial hardship, or that insurance provided under an insurance contract meets the borrower's requirements and objectives and the borrower can make the payments without suffering substantial hardship. The records must be kept for at least 7 years after the relevant inquiry. You may keep the records for longer if you choose to do so. 9CA records may be requested by the Commission, noting that the Commission doesn't need to use its statutory notice powers to make the request. A person responsible for an approved dispute resolution scheme who may request records that relate to an agreement or relevant insurance contract that is the subject of a dispute under that scheme, or by a borrower or their representative acting for them, may request records about inquiries made by the lender under Sections 9C3A and 5A that relate to an agreement or relevant insurance contract to which the borrower is a party. A guarantor may request records about inquiries made by the lender under Section 9C4A that relate to a relevant guarantee to which the guarantor is a party. If you receive a request, you must make the records available, and the records must be provided within 20 working days of the request being received, or within a longer period if specified by the Commission. A further requirement under Section 9CA is that the records must be provided free of charge to a borrower or guarantor. Moving on to Section 41A, it specifically requires you to keep records about how you calculated credit and default fees for the purposes of Section 41. The records must demonstrate that the fees were not unreasonable at the time they were calculated or reviewed. There are several things you must do under Section 41A. Review a credit or default fee if you know or ought reasonably to know that there has been a change that is likely to materially affect the reasonableness of the fee, and reduce the fee if the review finds it is now unreasonable. For example, if a change in the company's costs or business structure has affected the amount of a credit fee. We sometimes see fees that have decreased as a result of changes and following review are either removed altogether or reduced. As per our fee guidelines, the Commission's expectation is that a lender remediates customers if it identifies it has been charging an unreasonable fee. You must also keep the records for at least 7 years after the date on which the fee is calculated or reviewed. You must also make the records available to the Commission on request, again noting that the Commission doesn't need to use its statutory notice powers to make the request. And you must also make the records available to a dispute resolution scheme on request. As under 9CA, if you receive a request, the records must be provided within 20 working days of the request being received, unless the Commission specifies otherwise. The following are some general comments that relate to compliance with both sections. It's important that the information recorded and provided demonstrates your compliance with the respective requirements of sections 9CA and 41A. You must ensure your records are fit for their intended purpose, which includes disclosure on request to the Commission, Dispute Resolution Service, the borrower or guarantor. The Commission or any requester should not have to try and work out what you've done. We should be able to look at your records and be able to easily follow the process or review you've undertaken from the records you provide us, what information you used, any calculations you've made, and conclusions you reached. It's important that you think about your reporting obligations at the time, rather than creating or pulling together records after you receive a request. If you receive a request and you don't have the required records, you probably haven't complied with the requirements and there could be consequences for that. We recommend that you build the new requirements into your existing CCCFA compliance processes. Now, specifically for 9CA, the way you provide information in response to a request depends on what and how you collected and recorded information, verified it where required, and made your assessment. You are not required to make records in order to comply with the request. In fact, as I've already flagged, if you have to create records after you receive a request, then you have not complied with the obligation to keep records that demonstrate how you have satisfied yourself with the affordability of the loan, or that the guarantor can comply with the guarantee without suffering substantial hardship, or that the insurance provided will meet the borrower's objectives and requirements before any loan, guarantee, or insurance contract is entered into. Providing copies of the borrower's documents and information on their own is unlikely to be enough to demonstrate how you've made all necessary inquiries. Your assessment and calculations will also be needed to show us how you satisfied yourself that the loan was affordable. For example, if bank statements are used to verify information from a borrower, those bank statements must be provided and the record should demonstrate the bank statements were used to evidence that the affordability assessment was satisfied. Confidential information must be provided to the Commission if it formed part of your assessment. You should mark it as confidential and explain why when you provide it, so we know what the issue is. The same applies to personal information you have collected from a borrower or joint borrowers to meet the requirements of Section 9CA. You may already know that there is a section in the Privacy Act 2020 that confirms that the requirement to disclose personal information under the CCCFA sections override any limitations on disclosure in Information Privacy Principle 11 of the Privacy Act. Records provided under Section 9CA must show the way you stepped through the affordability assessment. For example, you should keep a record of likely income, evidence for that income, any statements about likely changes to income, likely relevant expenses, a list of relevant expenses and estimates, copies of information or documents obtained during inquiries. For example, a credit report, benchmark information if relevant, a statement if a buffer or adjustment was applied, etc. You will also need to either concisely summarise your decision or make some other record of how you satisfied yourself the loan was affordable and suitable, including references to your policies and procedures. We are expecting to see not just the records of the inquiries, but also something that records the outcome of the affordability assessment. For example, X income, X expenses, X buffers or surplus, showing that income exceeded expenses and there was a reasonable surplus or buffer. If you use the obvious affordability exception in Regulation 4AG, you should keep a record of the specific inquiries made, the result of those inquiries, and the reasons why it is obvious in the circumstances that the borrower will make payments without substantial hardship. For Section 41A, as well as keeping records at the time the fee is set, you must keep records of any review of fees when you become aware, or ought to be aware, of a change that is likely to affect the reasonableness of the fee. For example, if you have made changes to your business or cost structure and it results in the amount you need to recover from an existing fee reducing, you need to review the fee and reduce it accordingly. The records must demonstrate that each fee was not unreasonable at the time it was set or reviewed. Your records should include any costs identified as being closely related to the activities giving rise to the fee and explain their connection to the fee. The kind of records you may need to make are identifying the recoverable portion of any closely related costs and set out how that proportion has been calculated, the basis for determining the amount of the closely related costs, including information that you use to make any forward-looking estimates, document the anticipated number of transactions over which the costs are expected to be incurred that has been used as a basis for fee calculations, set out the assumptions on which the fee calculations are based and the basis for those assumptions. For default fees, identify and quantify any assessment of loss that could be incurred on a default as a result of the acts and omissions of the borrower that you wish to recover through the fee. If you don't comply with the requirements of Sections 9CA and or 41A, the Commission has a range of enforcement options. For example, if you are found to have breached your obligations under either section, then you may be ordered to pay pecuniary penalties of up to $600,000 for a company or $200,000 for an individual. If you do not comply with a 9CA request from a borrower or guarantor, they are unable to bring a proceeding directly. But if they notify the Commission of your non-compliance, the Commission may decide to bring enforcement action on their behalf. And finally, you should also remember that due diligence obligations mean that directors and senior managers will need to have taken reasonable steps to ensure there are systems in place to ensure compliance with Section 9CA and also the requirement under Section 41 to not be charging unreasonable fees. So ka nui tēnei, that is all from me. Thank you for listening and coming today.